So here with me today is Janelle Edwards-Stewart. She is an attorney with the law firm of Porzio, Bromberg, and Newman out of Morristown, New Jersey. And she is part of the litigation team that just won Litigation Team of the Year award for 2016 in the state of New Jersey. Congratulations, Janelle. That's a fantastic achievement.
Thank you.
And Janelle specifically practices employment and education law and counsels clients who are generally company owners, managers, schools, and school districts on how to address disabilities and disability accommodations in the context of work and school. Janelle, I am really appreciative because I know this affects perhaps hundreds of thousands of New Jerseyans, and of course people from around the area, because of course a lot of New York, New Jersey, and so much of this area intermingle. So this really does affect a large percentage of our viewing audience. So first of all, there's something called the ADA. Could you please explain what the ADA is and how it affects people?
I sure can. Thank you, Vivian, for that lovely introduction. The ADA was established in 1990 to offer broad protections to individuals with disabilities. And by broad protections, what I mean is that the ADA not only prohibits discrimination against individuals with disabilities, but it includes an affirmative obligation to offer reasonable accommodations to disabled individuals.
Now, when you say reasonable accommodation, so we're talking naturally at work and school. So there my question lies. Who decides what is reasonable? Is there a panel somewhere? Is it the government? Who does make that judgment call of what is deemed to be reasonable? Because, for example, what is the percentage of small business owners in this area? I believe it's something to the effect around 30 to 35% of the population is a small business owner. And of course, it's an average of 45% of the workforce employed by small business owners. So this is quite substantial numbers. So, but unfortunately, a lot of accommodations could be potentially cost prohibitive. So who has the right? Is it the small business owner that by hiring someone who might have a handicap that might not even be obvious? What happens if they don't make this accommodation? And there's all kinds of accommodations. What if they have and I've even heard about this, a comfort animal? I mean, there's all for somebody who may have a psychological challenge. And when you hire someone like that as a small business owner, this disability is not visible. It's not as if they're walking in with a cane or a wheelchair that's visible. So could that be something that could happen in the workplace or at school?
So there are a lot of questions that were built into that, and I'll try to tease them apart as I address them in portions. But I'll start with a number. First of all, you're right. A lot of potential accommodations could be quite cost prohibitive for employers, and that is part of the analysis. So no, it's not going to be the case that an employee can, simply dictate some extraordinary, accommodation, and then on their own, the employer is obligated to fulfill that obligation. It's quite a ways away from that. But I'll start with, first of all, who needs to comply with this. It's not every single small business owner. As of 1994, the ADA really applies to employers of 15 or more employees.
I see.
So starting there, what should happen is that the employee is the one who really is obligated more or less to place the employer on notice of the fact that they are an individual with a disability that needs an accommodation. And then from that point, there needs to be sort of a reasonable discussion and a collaboration to figure out what kind of an accommodation is most appropriate for the employee. So really, the employee and the employer together figure out what the accommodation ought to be.
I see. So going into what type of disabilities can occur. So obviously there's many types of obvious disabilities. For example, if you have a child who's autistic, that may become obvious, or Down syndrome, or in a wheelchair for whatever reason. But would someone who has a learning disability fall into the same guidelines? Perhaps they have an IEP at school?
Well, actually, the sort of example that you're talking about triggers a number of different federal and state statutes. When you're talking about a disability as far as the ADA protects individuals who are disabled, and by disabled it means that they have a physical or mental impairment, so a specific learning disability, something like that would qualify as a mental disability, but it needs to be one that substantially inhibits a major life activity. And so major life activities can be things like walking, talking, hearing, seeing. As long as there's one or more of those that are substantially impaired, they can be regarded as a disabled individual under the ADA. In terms of students within an education context, there are other laws that come into play, such as the IDEA, that's the Individuals with Disabilities Act, and you referenced a moment ago IEPs.
Correct.
Those are individual education programs that are designed to help students with their behavioral or mental or learning disabilities. So it's a collection of items that are discussed amongst a group of experts within the school who together with the parents sort of figure out how do we address the student's learning needs.
So let me go into now the workplace environment. I actually have a friend who has a child who's autistic.
Okay.
And unfortunately, his wife is not a driver. So he then has to take the time off of work to take his son to appointments, whether they be doctor appointments, they're looking into a specialized school. Now, he happens to own his own company. Thank goodness this isn't something he has to report to a boss about. But let's face it, not everyone's going to be self-employed with this issue. There's a lot of cases where what work is given to someone could maybe be up to the employer's discretion, their immediate supervisor. Is there a case where if someone feels that they've been discriminated against because of their home obligations? So let's say my friend was employed at a traditional company, not self-employed.
Okay.
And he had project work that he had to take care of. Perhaps his supervisor deemed that because of having the obligations of taking his son to doctor's appointments, he shouldn't be given a more prestigious project to work on. And is that possible that that is a discrimination at the workplace because of his child's impediment and his home circumstances?
Well, as I indicated before, the ADA does protect individuals with disabilities themselves. And in this particular scenario, what you're suggesting is that the employee is not the disabled person, but rather their child is the disabled person, and that they may need some sort of accommodation for working or going home rather to take care of their child. Under the ADA, there are a lot of accommodations that can be made. Work schedule flexibility, that's one of the things that can be treated as an accommodation for a disabled employee, let's say. If the employee finds that they are being discriminated against, or he or she is being discriminated against based on their child's status as a disabled individual, then that is something that the ADA actually offers protection for.
That's good to know.
What the ADA does is protect individuals who have known associations or relationships with disabled individuals so that they are not punished based on those known associations or relationships.
So someone who's they themselves are not disabled, but they are a parent, for example, of a disabled child, they would still be afforded those benefits through the ADA.
They are not permitted to be discriminated against based on their relationship with their child or their association with their child.
So let me ask you this. If that does occur and they feel that they were treated differently in the workplace because of that, is there a potential for a discrimination lawsuit there?
Well, I mean, typically you want to have conversations before you have lawsuits. So
potentially, though. I mean, you want to talk to your employer, but what if the employer says it comes out and says it? Well, this project is very timely, and I don't believe you have the time because you have to take your child every Tuesday or whatever the case may be. And the employee said, well, if you had just given me a chance, I would have found another accommodation somehow, some way. And they just don't see that they can come to an agreement on that. What can someone do in that case? Is there any kind of recourse?
So there are a couple of things I think are involved in that question. One of the things has to do with the ways that an employer can treat an employee who he perceives to be disabled or who he or she perceives to be affiliated with someone who's disabled. They will not be able to discriminate against the employee in terms of hiring, promotion, job assignments are one of the things, right? So the ADA does not allow for employees to be discriminated against in any of those areas. Project assignments would be included among those things. But again, if the employee actually thinks that they qualify for a accommodation, it would be the employee's obligation to make sure that the employer is aware of any accommodation that he or she might need, including work schedule changes to deal with different things, so that perhaps they can take on different assignments or limit their commitments in the workplace.
What I love is you're an attorney. explaining how we can come to agreement instead of jumping to a lawsuit.
It's true. It's
great.
true. A lot of, the practice that I do is litigation, but the things that you don't hear about, the things that don't become litigious, because really this is designed to create a space. The reasonable accommodation is a space where employers and employees can sort of figure out what works. A lot of times what employers are most concerned with is, costs. And am I going to not have a person be able to fulfill the obligation that I actually, hire them to fulfill? So those are the concerns that are on the employer's mind, and we as counselors for largely management side employers, we help them to think about what are cost-effective, efficient ways that it can actually still go ahead and accommodate their employee.
Well, you are someone, as an employer especially, when you're looking to minimize, because of course as employers they're always worried about employee retention, because it is far more expensive to obtain a new employee than it is to accommodate a current employee that they're otherwise happy with. Thank you very much, Janelle, for coming on the show and educating our audience on how to handle any kind of potential conflict with either yourself or a family member with a disability.
Thank you for having me, Vivian.
Thank you so much.